Mr. Gannon, Deputy Solicitor General, argued as an amicus curiae or friend of the court.
Mr. Chief Justice, and may it please the court, Wisconsin has opted into the cooperative framework of the Federal Unemployment Tax Act and has enacted the federal statute's exemption for religious employers, which applies to certain church-controlled organizations that are, quote, operated primarily for religious purposes. Petitioners serve as the social ministry arm of a diocese of the Catholic Church. They correctly told the Wisconsin Supreme Court that they qualify for the exemption under the statute. That court erred in its reading of the statutory text, and because it explained that the Wisconsin statute conforms with the federal one, this court should correct its mistake. That would avoid serious constitutional questions, just as this court did when it construed FUTA's religious employer exemption in St. Martin in 1981. If the court reaches the constitutional question, it should reject the Wisconsin Supreme Court's analysis, which second-guesses the religious nature of sincerely held expressions of faith, and worse, risks discrimination among various faiths by singling out certain activities that are deemed inherently secular. I welcome the court's questions.
In short, the Department of Justice under the current administration thinks the Wisconsin Supreme Court got it wrong. First, because the Wisconsin state law matches the federal one, and previous courts have found that what Catholic Charities does is primarily for religious purposes. Second, even if the court doesn't find on the statutory grounds, the Wisconsin Supreme Court erred by second-guessing Catholic Charities' religious purpose. Justice Gorsuch brought up the idea of proselytization and brought it back into the discussion.
On the discrimination grounds, why would we have to get into any of that? There's no dispute that Catholic Charities exist primarily for religious purposes. There's no dispute about the sincerity of their religious belief. And the only question is whether it's treating different religions differently because some proselytize when they provide services and others don't. Wouldn't it just be that simple?
I agree with all of that. I think that the biggest problem with it is that it grants what we think is a wrong reading of the verbatim text of a federal statute.
This idea that Catholic Charities does not proselytize or attempt to convert someone to their faith seems to be a big hang-up for the Wisconsin Supreme Court. This discriminates against different organizations based on how they exercise their religious beliefs.
That is correct, but we also think that there shouldn't be a dispute that it is operated primarily for religious purposes, because what the court should not be doing is looking at particular activities and defining them as inherently secular or inherently religious.
That's the discrimination problem.
That is a similar problem even for purposes of construing the statute.
Interesting, the Wisconsin Supreme Court, in an attempt to avoid entangling itself in religious issues, entangles itself by defining what is and is not a religious purpose. Justice Jackson attempted to define purpose not by why something is done, but by what is done.
But there's another idea of purpose that would be, what is this organization's activities about? What are they offering? And I guess my concern is that view of purpose seems to make more sense of the exemption in this case. I mean, if the two hospitals, the Catholic hospital and the secular hospital, are performing the same services, I don't understand why one would be exempt just because they have religious motivation versus the other. I don't know what the statute is doing to make that kind of distinction.
It seems Justice Jackson has an issue with the definition of the word purpose. She equates purpose with what is being done and what services are being provided, not why they are provided. Merriam-Webster defines purpose as something set up as an object or end to be attained. To use Justice Jackson's example, a hospital could treat patients simply for the financial gain or because their religious doctrine tells them to heal the sick. One is a religious purpose, the other is not. But there appears to be more to Justice Jackson's conclusion.
No, what I'm saying is, if you are right that the line that's being drawn here is about motivation, I don't understand how the exemption works. There must be some rational reason why Congress would want to exempt the exact same kinds of services being provided just because they're being provided by somebody who's religiously motivated versus, the restaurant we have two identical vegan restaurants. One is being run by people who say this is a tenet of our faith and we're doing it in order to be a ministry for our religion. And the other is run by a person who has no such motivation. why would one rationally be under the unemployment exemption and the other one doesn't?
How about the First Amendment's requirement that Congress not make a law that prohibits the free exercise of one's religion?
If you instead think of purpose as not motivation, if you think of it as the actual services that are being provided, and the distinction is in that, then Wisconsin says the reason why we're exempting novitiates is because if we don't, we're going to get entangled in religion as we try to adjudicate those kinds of claims. It only makes sense if purpose is focused on the activities rather than the motivation.
Actually, Justice Jackson's statement, it only makes sense if purpose is motivation, not as service, doesn't make sense. Does a doctor perform an appendectomy for the fee he collects, or is he motivated by a religious duty to heal the sick? Does he waive his fee for tax purposes, or because his religion tells him to help the poor? No, Justice Jackson, the service is not the purpose. The motivation behind the service is.